Hi, I'm attorney Gregory Dell, joined by attorney Stephen Jessup, and today we're going to talk about one of Stephen's recently resolved cases against MetLife Disability Insurance Company. And Stephen, in these videos we like to talk about the background of the case, how you helped the claimant, what the reason was for the denial, and then provide some tips for people that they can gain to possibly help them with their MetLife claim moving forward. So give us a little bit of the background of this particular case.
So this case it's old. It's got quite a few years on it. It started in 2016. The client was a former senior research associate for a company doing scientific research, a high wage earner. She went out initially on disability, and MetLife approved the claim for, strangely enough, radiculopathy, and then also for mental health purposes. Now, as we've discussed plenty of times, MetLife writes very interesting policies, especially regarding limitations for how long they're going to pay certain claims. And the two biggest ones for them are the 24-month mental health limitation, which is common to most carriers, and then a 24-month, what they call a neuromuscular, musculoskeletal soft tissue disorder limitation, where they try to basically limit every physical condition under the sun, unless you have evidence of a handful of qualifying related conditions.
Okay, just to back up, what was the occupation of this particular
She was
claimant?
a senior research associate. She did scientific research.
And her diagnosis, radiculopathy, from what part of her body?
You know, it was stemming from lumbar herniations.
Okay.
And this is important because later on in the process, MetLife changed their tune as to what the disabling diagnosis was. So it was a lumbar back surgery. She had evidence, of radiculopathy, not supported at that time by EMG or nerve conduction studies, just clinical exam by her doctor, and then also, secondary depression and anxiety, diagnosis.
Okay, so interesting you said not supported by EMG. What is the best way to document a radiculopathy according to medical literature?
EMGs and nerve conduction studies are the objective evidence. It's like if you have a bad back and you have herniations, they do an MRI. That EMG and nerve conduction study is usually the gold standard of what the insurance company is looking for to support the evidence of the radiculopathy, even though it doesn't always necessarily document it, and you have to argue the existence of it, in other ways. But at this time, they approved it without her having that information in her file.
At which time, initially?
Initially, correct, sorry.
And how long did they pay her for before they denied benefits?
So this is prior to my beginning representation, but then correspondently speaking, like heading into 2018, so we're talking about the 24-month own occupation, any occupation switch, they had issued a letter that said, oh, we've learned that you have a new diagnosis of post-laminectomy syndrome, which is kind of like a failed back surgery. Mm-hmm. We are going to evaluate as to whether or not that is disabling you, and we are, we don't find evidence of radiculopathy, so you'll be limited to 24 months. And then also your mental health claim, that's going to be limited to 24 months. That date of, termination is coming up. So it was like a three-prong attack of ways they were trying to find to deny her. Two under policy limitations. And then the one they paid the least attention to was this idea of own occupation versus any occupation.
Okay, so did she get paid for 24 months and then get denied?
24 months, and then they did continue to pay her for a little bit beyond that point before they denied it, saying that her conditions were limited to the limitation. So it wasn't that they weren't saying that she would be able to work in any occupation. It was, we only have to pay you 24 months, we know you still have problems, we're sorry, but our liability is only to this 24 months.
And was that under the neuromusculoskeletal limitation?
Correct.
And this neuromusculoskeletal limitation is commonly found in most MetLife group disability policies. What is the gist of what it says?
If you have a condition of the joints, the spines, the surrounding soft tissue, things along those lines, your claim will be limited to a maximum benefit period of 24 months. In a lot of ways, this started to really come about after you started seeing, fibromyalgia as a diagnosis, actually getting, foothold in the insurance community. And much like mental health conditions, their opinion, it's all subjective. So the best way to address it is try to limit it. So that limitation, in my opinion, stems from that. And then chronic pain, and if you have arthritis, and if you have, disc herniations, or if you've had back surgery even, it's ways to try to limit it to 24 months. Now, there are exceptions to it in the way that the policy is written. is, this will be limited to 24 months unless the condition has evidence of, and then there's a handful of things, radiculopathy being one of the biggest ones, certain other type of, conditions, and, if there's tumors, if there's nerve cord impingements, there's varieties there. Radiculopathy is the most common, and in this case, that was the grounds that we were going to argue on.
And what type of medical review did MetLife rely upon in order to deny benefits?
They just did internal pair reviews. So they had, outside, they weren't internal doctors, but outside doctors that were hired to take a look at it to determine if there essentially was evidence of, radiculopathy in the file. And their argument was there was a lack of any objective proof of it. It was just, the subjective complaints of the client.
So, but were they saying that they didn't think she was disabled, just that she didn't have enough objective evidence?
So there was never the argument, they never got to the point where they said, we think you can work. There was never that you're not disabled. It was, we understand you have these conditions that impact your ability to work, but under our policy, we only have to pay you 24 months. This is what happens in any mental health limitation as well. There could be no question that an individual can't go back to work, but the liability under the policy is only for the 24 months.
Okay, so what was your strategy and what did you end up doing on appeal?
Twofold, because I've dealt with this multiple times with them. And sometimes, there's a rush, and I've seen it happen in reviewing denials later. For other people who contact us when their appeal's been denied. There's a rush to prove the radiculopathy and only prove the radiculopathy. The way I handled the appeal was, I said, listen, we have to have the EMG and nerve conduction studies performed. There was the clear evidence of radiculopathy. So I was confident I could obviously get over that limitation. Also, from my experience in seeing, sometimes I've seen MetLife try to argue, okay, so you have radiculopathy. We are going to evaluate to see if the radiculopathy is in of itself disabling. But like I said, the way the policy is written, the condition would be limited to 24 months unless there's evidence of radiculopathy. I read that to mean that if the radiculopathy, there's evidence of it, everything is still involved. So I was confident I could get beyond that 24 months limitation. But then the bigger thing is knowing that then they would automatically turn to a review of, can she do some other occupation? Now it's a matter of, is she disabled? So to address that, we also did a functional capacity evaluation to document her restrictions and limitations. And since her occupation was sedentary, we were trying to bolster and show, she still couldn't perform any occupation at a sedentary level. Common sense arguments aside of, well, if she couldn't do sedentary before, what makes you think she can do it now? So I not only addressed getting around the limitation, but also establishing that she would remain disabled under that any occupation standard.
And you mentioned the functional capacity exam. What is that, and what type of expert did you need to retain to administer that type of testing?
So functional capacity examination, and I tell people, and, a lot of times with medicine, there's no perfect science, but the functional capacity evaluation is, again, one of the gold standard tests to determine someone's physical restrictions and limitations. It's generally done by a physical therapist, even though it can be done by, some doctors do perform them. But in the testing, what they're doing is they're trying to understand, based on Department of Labor, guidelines for sedentary, light, medium, heavy, very heavy, where someone falls. The testing is only 2, maybe 3 hours, depending, and then from that they extrapolate ability for work over a 40-hour work week.
And then is there some kind of report generated with that?
Yeah, there's a report, it has all the hallmarks that you see in those Department of Labor definitions of what sedentary work is in this case. Sitting requirements, lifting, pushing, carrying, pulling, all that type of stuff.
Was there any kind of income component in the any occupation definition in this particular policy?
In her policy, no. There wasn't any. Sometimes they do write them in them. Like it would pay 60%, so basically it would pay your monthly benefit. This one didn't, but given her training, education, and experience, it was still one more of those things, in my opinion, that she was pretty pigeonholed into what she was doing. She was, as I always say, what I do with law, one-trick pony. She knows how to do this one thing. She's done it for so long. So the argument and the vocational side of it for me was more going into a generalized idea. She couldn't do sedentary work before. She can't do sedentary work now.
But in your appeal, they hadn't denied on the basis of saying, we think there's other jobs you can do. You were just anticipating that because you knew you were going to get over the neuromusculoskeletal limitation by proving objective evidence of an EMG or radiculopathy. and you wanted to anticipate the argument that, okay, if I win that, I know how MetLife plays the game. Now they're going to say, well, we think you can do this, this, and that job, and you didn't want, so you anticipated that.
Exactly, because one of two things. They likely what they would have done is said, all right, we find that she's not limited to this, but we're denying for any occupation, then you have to go through a whole nother appeal potentially. So I wanted to avoid that as much as possible and get everything hammered out the first time.
What do you think your client could have done differently to have avoided a denial?
I mean, honestly, probably have gotten the EMG or nerve conduction studies, but she wasn't necessarily aware. It wasn't something, it's not in her daily lexicon. This is what I need to do. In handling these cases, I know, we know what kind of information is going to be needed to help support a position, but that's something that could have, probably been done to avoid it. But that's not to say they just couldn't have denied it for some other reason. It just would have taken away one of the arguments.
It's not uncommon that a doctor doesn't request an EMG or nerve conduction study test. Why is that?
Generally when they do like clinical exams and stuff and sensory exams and stuff like that, they can understand and take the client's complaints and what's happening, based on if there's a surgical history or, from MRI evidence, there's usually enough that a doctor can say this is probably what you're experiencing. We don't necessarily need to figure out what disc level it's coming from. We know what level it's coming from. So I think, they're probably thinking it's not needed. I can make that diagnosis, and EMG and nerve conduction studies are not comfortable tests. You are being, shocked. So if you can, avoid having to send one of your patients through that, I'd imagine that's why doctors, generally will try to avoid those.
We always say, and this is a reality in the medical world, that the doctor treats the patient and not the chart. So the doctor is looking at the MRI, looking at X-ray, listening to the patient, and says, okay, I know what's going on with you, I know how to treat you. I don't need this EMG test to tell me or to confirm what you're saying, because you have no incentive to lie to me, and if this is what's going on, I'm going to treat you the same whether that EMG comes back negative or positive anyhow. And we've had many cases where the person has all the same symptoms as your client and the EMG comes back negative. Now, if that was the case here and that EMG came back negative, I know you've still been able to have success to try to prove that the person has radiculopathy. How can someone do that in that case?
Again, then that's really how much the doctor is willing to support and really go into those things, because we've had situations like that. You and I represented a dentist with carpal tunnel who'd had release surgery, and his surgeon was a leading expert in it. He's like, I know what radiculopathy is. I could open up a wrist and tell you that there's impingement, that there's not radiculopathy, but there's going to be EMG findings. There's going to be a problem. So it really becomes the doctor getting involved in trying to establish from clinical notes and that. I have been successful, but a lot of times insurance companies will just, especially on a group disability policy governed by ERISA, they're going to rely on their doctors and say we don't see proof of it, and they're going to push the denial.
Right, so I want people to know there's other arguments that can be made. You don't necessarily have to have this positive EMG or a positive MRI finding. That you can prove through other modes of evidence on a case-by-case basis to get past that neuromusculoskeletal limitation. And one last thing, you mentioned something about a mental nervous. Where did that come into the mix in this particular case?
I think, so it was secondary. There's history. She was treating for depression and anxiety. It probably in and of itself probably could have been disabling. And I think this is also just, MetLife and insurance companies learning how to handle things, because I've had situations where they've approved only for physical, and then they say the physical is not disabling, but they never approved for the mental health. And then all of a sudden, like, okay, so now we find mental health, we have to pay 2 more years on top of it. So I think they approved for both the physical and the mental health from the get-go. So they were running at the same time. So that 24 months was going to be a hard done. As opposed to if they'd only approved her on the physical side of stuff, and it's there in the award letters, what they're approving for and all that type of stuff, and in the claim file, I could have made an argument if the physical wasn't going to stick. Well, you didn't evaluate, is she disabled from mental health properly? You haven't had it even reviewed. So they did that, I think, initially, so that argument would be taken away later.
Now, this particular client's been on claim disabled since 2016, and talking before we started filming, you said that the whole thing's about to start over again.
We just received a peer review that they're giving us an opportunity to respond to. This doctor feels that she can do full sedentary work. She hasn't been able to for 5 years now, and like we've discussed, especially with surgical history, everyone, the natural aging process and degeneration of the spine, it happens to everyone. So for someone who's already had surgery and has had problems, the best they can hope for is to stay the same, but understanding it's going to deteriorate. So there should be nothing, and there is nothing in her file that would support all of a sudden that she has this ability. So we're in the process of getting that report responded to by her doctors. And we're also looking into doing another functional capacity evaluation just to address that sedentary thing. Because despite the fact she's on Social Security and they're offsetting, because she was a high wage earner, she's still a nice financial hit to MetLife for at least another, I think, like 15, 20 years.
So, it's incredible. You and I know it never ends. Mm-hmm. You're never safe with these companies, and you have to continue to protect your benefits every step of the way. And I know you're continuing to represent her, which is what we do with all of our clients once we win the appeals, because winning the appeal is just, you got over a hurdle. You always have to watch your back, continue to protect the benefits throughout the durations of these claims. And MetLife is not unusual in this aspect. They're all the same, basically, because new people get on the claim, new claims person, new manager internally, and then they can find a doctor to say what they want to say. And that's, again, it looks like that's what they did. And so I would love to have seen that doctor, and I know your claimant would, to say, after 5 years, you think I can go to work? What did you find that all my doctors from the past 5 years haven't found? Make me better. Because I don't want your money, MetLife.
Yeah,
I want to get better.
I'd rather be back to work and not be in pain all the time.
Well, if you're someone who has a MetLife long-term disability claim, feel free to reach out to Stephen or myself. We'll always provide you with a free initial consultation. No matter where you live in the country, we're available to assist you, and we look forward to the opportunity to speak with you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.